Okay. Okay, people are starting to join, so we'll give them a couple of minutes to join us, and then we'll start. And of course, once I say anything, it's some sort of curse that the numbers start just stop going up. But anyway, okay, no, there are people joining us. Great. Okay, for those that have already joined us, welcome, and we're going to just give it another minute or so to let other people join, and then we'll start. Okay, I guess we'll start. I'm Mary Trosco, CLIA's Executive Director, and it's my pleasure to welcome you to tonight's presentation on copyright law. First, I'd like to acknowledge that CLIA's office is located on Treaty 1 territory, the traditional gathering place of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene people, and the traditional homeland of the Métis people. Winnipeg's water is sourced from Shoal Lake 40 First Nation. We acknowledge that much harm was done in the past and dedicate ourselves to move forward in the spirit of reconciliation. I'd like to also mention a little bit about CLIA. We do have a variety of programs. Our newest are our intimate partner violence and workplace sexual harassment projects, which involve both legal information lines and legal information presentations. If you visit our website at www.communitylegal.mb.ca, it explains our various programs. We have over 600 frequently asked questions. Under the video tab, you'll find over 60 videos on a variety of topics. We have an online course with 9 modules, and we also have various publications. Now I'd like to introduce our presenter, Althea Wheeler. Althea is a lawyer and librarian with degrees from the University of Manitoba and the University of Alberta. After beginning her career in family law, Althea obtained her master's in library and information sciences and found a perfect match for her legal and library backgrounds in copyright law. Althea works at the University of Manitoba, where her primary roles are providing copyright education and information for the university community. So I'll let Althea take it away. Thank you.
Thank you so much, Mary. And thank you for having me here to present today. So I will, of course, be talking about copyright law. As just a little bit of housekeeping, I'm going to warn you, I was having some trouble with my microphone, so I'm just using the one on the computer. So there's the possibility of background noise. I have a very noisy cat, so my apologies if she makes herself known. Also, I'm just recovering from a cold, so my apologies if I have to stop to clear my throat. But other than that, this should all, I think, go swimmingly. You've already learned a bit about me. I'm Althea Wheeler. Just a little note, and you probably, if you've gone to some of these presentations before, you'll always hear this disclaimer that this presentation is just informational purposes, not meant to be construed as legal advice. I'm also going to mention any views that I express, all my own, not that of my employer. We have a fairly small group today, so I think if people have questions as we're going along, I'm happy to take them. So if you want to put them in the chat, or perhaps we can even put a hand up. Yeah, happy to take your questions. So let's start with what copyright is. And we probably all have somewhat of an idea of what copyright is basically, but getting down to sort of the legal nitty-gritty, it is a statutory right, and it does come from the Copyright Act of Canada. So we can go to that statute and we can learn all about copyright and the different provisions in Canada. And we really need to look at it as an economic right in its basic respects. It's an exclusive right of the creator, or it could be the copyright owner, to do things like publish, publicly perform, copy, distribute, communicate, or telecommunicate, so make things available electronically, a work. And that could be a variety of things, such as a musical work, like a score, an artistic work, a dramatic work, cinematic graphic work, which is sort of a old-timey fancy word for video, um, or a literary work. Things like performers' performances can also be copyright protected in some cases, as well as broadcast signals. Another thing that's interesting about copyright law is that copyright can be jointly owned. When we have separate authors, we've all written something together, you can't really distinguish who wrote what part. That's going to be a joint copyright ownership. So in those cases, a copyright owner might have to either discuss with their other owners how they can reuse their work, do an accounting if someone were to use that work, perhaps without getting everyone's consent. But one way or another, copyright can also be something jointly owned. I mentioned copyright as an economic right, and I may be saying this because I'm coming from my academic background and perspective, but I like to point out that copyright and plagiarism, while they can overlap, they have similar concepts, these are separate. There can be situations where, since we're just looking at the economic right of copyright, there could be something that's done that's an infringement of that maybe is not plagiarism. So for example, if I use something perhaps in a way that was not permitted without consent of the copyright owner, even if I give them credit, that doesn't mean that it's going to be okay. Whereas from an ethical or plagiarism kind of perspective, when I reuse things and I make sure I'm giving that citation, that can be something that's ethical in that way, even if it's not copyright compliant. So I like to just point that out because sometimes those two things get a little muddled in people's heads, and I like to make sure we're distinguishing between the two when I'm speaking to you specifically about copyright. So what can be protected by copyright? A whole host of things. So I've mentioned artistic works, things that we'd expect: photographs, paintings, sculptures, literary works, so things like books, articles, poems. I mentioned computer programs here because the code for a computer program will actually be covered by copyright as a literary work. The rights of authors can also go to things like permitting a translation to be made in a literary work. And important to note, when I say literary work, I really just mean something that's written as opposed to something that's, for example, fictional. And that's sometimes something I hear some confusion about too. Dramatic works, we have plays and screenplays, etc. Musical works, so like a score, a performer's performance, when it is recorded in a format, that can have copyright protection too. Just a performance, if I do it on my own and it's in no way recorded, there's no way I can reproduce it, not going to have the same level of protection. And that's because, as you'll see a little further down in my notes here, to get copyright protection, a work must be fixed. It must be reproducible. I must have it either, say, in a hard format, so in print, something I've written out and can reproduce, or something that digitally, for example, a file that I can reproduce. Sound recordings get a copyright, that fancy word, cinematographic. So video recordings, broadcast signals, and just to note that there can be layers, multiple layers of copyright in a single work. If we think of something like a film, we might have music in it. So there might be copyright in the music in the film, copyright in the script, copyright in a recording, either of the audio or the video. So there can be multiple different rights we need to think about when we are thinking about how a work is copyright protected. So here's just a little word bubble again, making us think of all the different things that can be copyright protected. I mentioned government publications here because that's when I sometimes hear too, people say, well, I'm not too worried about copyright because I'm just reproducing government publications. And I have to say, actually, those are subject to something called crown copyright. So we do need to think about copyright with government publications. Something like a meme, again, something we don't always think about, but usually there's an underlying image in a meme. And that will be something subject to copyright protection. If we remember back, not popular now, but there used to be socially awkward penguin that we'd see quite a lot. We don't see it now. And I think that's primarily because that image actually belonged to Getty Images. And they started going around to bloggers and saying, you know, you're using an image in an infringing way when you use this meme. And it's kind of gone out of popularity. So there are many things that we don't always think of that actually do have copyright protection. And how can something qualify for copyright protection? It needs to be something that's sufficiently original and more than a mechanical copy. So I can't take something someone's already written, rewrite it in my own hand, pretty much verbatim, or say redraw a figure or an image that someone's drawn and say my new one will have copyright protection. That's just a copy. It has to be something more than that. It has to be original and it has to require a certain amount of skill and judgment. Copyright, however, does not protect ideas. So things like data, facts, equation, news, algorithms, simple drawings like a stick figure. Copyright law does not protect that because it's not meant to give a monopoly over ideas. Copyright law is about the expression of the idea. So the way I've written something, the way I've expressed or explained a concept versus the concept itself. And that's why we can do things like look at someone else's work, paraphrase it, write it in a new way, provide them credit. And copyright law would have nothing to say about that because there's no actual copy being done. There's just looking at similar ideas. And that's why we can have things like many movies on the same topic. We have the idea dogs can talk, and there are, as I'm sure we can all think, just in our memory bank, many films that are going to look at that concept and express it in very different ways. And no one can say, hey, that was my idea first. That's also why news outlets, of course, can all report on the news, the facts of the day. What they can't do is take what was written in another newspaper and just reproduce it without their permission. How can you get a copyright? In Canada, copyright is immediate upon creation. So basically, once I've met all these criteria, I've written something that's original, took skill and judgment, and I've made it in a fixed format in a way I can reproduce, there will be copyright protection. I don't actually have to register copyright. I can if I choose, but I don't have to register to the Canadian Intellectual Property Office. You don't need to see a copyright symbol in Canada either for something to have copyright protection. So conversely, when we don't see that symbol, doesn't mean that something doesn't have copyright protection. It's more a good visual notice is the way I usually say it. Under some international conventions, the copyright symbol is required. So in some nations, but I actually think we might be at the point where all those nations are also signed on to other agreements that would not require that. So it's probably something that, at least in terms of a legal formality, is becoming somewhat antiquated. And who can own a copyright? And you might think instinctually, whoever the creator is, that's the obvious answer. That's who's going to own copyright. And while that's generally true, especially in the first instance, it can actually be a variety of people who own copyright. It can be a creator, often a publisher, especially in certain kinds of publishing. A publisher will get copyright in order to make a work available. It can be an employer. Our default under the Copyright Act is if someone is acting in the course of their employment, creating work that's copyright protected for employment purposes, that's generally going to mean the copyright belongs to the employer. Sometimes there will be agreements to the contrary, for example, a collective agreement that might allow copyright to retain with an employee, but our default is usually if you're doing it for work, it's an expectation of your work, and you're making something copyright protected, often the employer is going to have the copyright in that. Copyright lasts after the death of the creator. So an heir, a surviving spouse, someone like that can also own the copyright in a work. A corporation or organization does not have to be an individual person, and it really could be anyone that the creator gives or sells a copyright to. And in legal terminology, we'll call that an assignment of copyright. So copyright can be given to others. So it's not always going to be completely intuitive who a copyright owner is. Sometimes we have to do a little investigation about this. The other thing that we get from the Copyright Act, in addition to our economic rights, are moral rights. And these moral rights are the reputational rights that the Copyright Act gives to creators. And in this case, I say creators specifically. This won't necessarily also be the copyright owner, because this is about the reputation of the creator. And these rights can be retained. I can keep them, or I can say I'm not going to exercise them and I can waive them, but I can't give them to someone else. If I'm the creator, they will stay with me. And there are 3 rights under Canadian law. One is attribution. So you can decide to have your name used with the work, use a pseudonym, or to be anonymous. Another one of these rights is integrity. So that's to have non-modification or mutilation. That's another fun copyright word. Non-mutilation of a work in a way that would hurt the creator's reputation, and then association. So having the work used only in ways that will not, again, harm the creator's reputation by association or by not having appropriate attributions, etc. So these are another important type of rights. We don't find them in all nations, but in Canada, we have a pretty good set of moral rights that creators can rely upon. So next, talked about some of the rights of creators. What if someone's doing something that the creator or copyright owner has not permitted? That would be a copyright infringement. And that's using a copyright protected work in a way that was not permitted by the copyright owner, or by, I'm realizing I need to add this in here for next time, or by an exemption, a permitted use under the Copyright Act. That will be an infringement. And that can include things like downloading or uploading a work without permission, or distributing copies, publicly showing or broadcasting a video without consent or payment. Those are all things that could constitute a copyright infringement. And an infringement can have civil, so financial consequences, and we probably expect that. We've probably heard about copyright lawsuits, someone saying, hey, you used my work without permission, I'm entitled to some compensation for that. But interestingly, and we may or may not be aware of this, there can also be criminal consequences, specifically for commercial copyright infringements in Canada, if they amount to a sort of a certain standard. The Copyright Act also, we can look at something called statutory damages. So let's say for a non-commercial infringement, there are certain amounts that someone can say, just by the fact you did this, I should be entitled to under the Copyright Act, up to $5,000 for non-commercial and $20,000 for commercial, if I'm not mistaken. But there can also be damages that will be in the amount of what the actual cost was. For example, if an infringement did mean a big loss to the creator or the copyright owner. So your own copyright, if you're thinking about that and how you protect it, I always suggest using the copyright symbol. As I said, not required. It's not a legal formality. I like to think of it as a good notice to the user or reader, because that's something, as I say, just in practice, I hear people sometimes say they're surprised they didn't see the copyright symbol. They assumed there was no copyright. So a good way to protect from people thinking that is to use that symbol. You can, as I said, you don't have to, but you can register your work with Canadian Intellectual Property Office. It costs $50 for a registration. The benefit to that is, of course, that you can easily prove you created something, the date upon which you registered it. So if there ever was an issue in future, or if someone used your work, you'd be able to show, look, I did create this. I have the registration. It would help if you had to protect it in that way. I mentioned mailing a copy of work to yourself. Sometimes people call this a poor man's registration. It doesn't really have a legal effect, but the benefit to this is that if you don't open the letter, you can show the date upon which you sent yourself something. So it could evidentiary, it could prove that something had been created by you at a certain date. So if someone else, started using the same thing, you could say, I can show that I actually created this first. If you do find something that you created that's illegally being shared online, I recommend taking action as soon as possible, because, of course, the longer you let it go, the more likely it's going to end up in other places. And a lot of sites, especially things like YouTube, etc., they're going to have policies that will help you to get material taken down. If they're centered in the US, they'll have something called a DMCA notice that you can use. Sometimes other processes by which you can ask for materials to be taken down from those sites. But the sooner you do it, obviously, the better. So I've talked a bit about the rights of creators, the economic rights we have under the Copyright Act, but there are also exceptions to copyright infringement, or times when we may not have to pay royalties that I'm going to mention too. I'm going to talk a bit about reproduction for private purposes, when radio performances can be publicly played, fair dealing, which is known as a user's right under the Copyright Act. It's a very common and powerful exemption to use. Pardon me. The user-generated content, or YouTube exemption, And then I've mentioned them here. I'm not going to go into them in detail. They're more just something important to know about if you do happen to be in an educational institution or a library. But there are a series of exemptions that are specific to those kinds of nonprofit educational learning centers that allow them to do broader things with copyright protected works as well. So first, reproduction for private purposes. This is a really interesting exemption under a Copyright Act, and it does allow us to make copies of copyright protected works specifically for private use where, number one, the copy is not made from an infringing copy, so it has to be a legal copy of an item that you're making this private copy of. It has to also be obtained legally, so other than by borrowing or renting, you must maybe have been given a copy of it, purchased a copy of it, not something where I can go to the library, take a copy of a book and use this exemption to make my own private copy. And when you are making the copy, you must be authorized to use the device on which you're reproducing it. Here, when we're making the copy, we can't circumvent a digital lock or technological protection measure. The Copyright Act says that although there are these exemptions or these situations in which we can use copyright protected works without having to get permission, we can't exercise these exemptions if there is a lock, if the creator or the copyright owner has done something to make it so we can't just make a copy easily. So what could constitute a digital lock or a technological protection measure? Often password protection is used as a technological protection measure. And generally, I tell people if we can't do something really simple like right-click, copy, and make a copy of it, or if I have to use another program or software in order to extract something, usually there's going to be a digital lock or technological protection measure that means I'm not permitted to do this. Once you've made that copy, you can't give away the reproduction. That copy is for your private purposes, not something that you can give or sell to others, for example. No renting, distributing, performing, etc. And the other thing about this is, although I can make this copy for my own private use, I can't get rid of the original and then keep my private copies. I would have to destroy them as well if I got rid of the original. I mention this because it's a question I get quite a lot. When can I play music in public? Playing recorded or live music is going to be subject to royalty payments to collective societies, SOCAN or Resound. They get tariffs from our copyright board, which will say in certain situations, for example, in a business, at a wedding, fashion show, you will pay this amount of money based on how many people are there or whatever other criteria there are in order to play that recorded or live music. There is an exception to this, and I mention it very frequently, that you don't need to pay those royalties where you're playing radio performances. So, and that's in places other than theaters. There is even an exception to this. But generally, we can play radio in public without having to worry about paying any additional royalties or fees. And that's because the radio broadcaster is the one who's already paying that royalty to SOCAN and Resound, not you as the end user. So that can be one that people are very interested in. Next, moving on to fair dealing. Fair dealing, as I mentioned, is a user's right. And it is one of the, I'd say, most commonly exercised rights, especially for education and actually for many purposes. It comes to us from Section 29 of the Copyright Act, and there are a series of purposes that our government has said, yes, you may fairly deal for. So we can use excerpts or parts of copyright protected materials for things like research, private study, education, criticism, review, news reporting, parody, or satire. And this is a closed list. These are the only reasons for which we can fairly deal in Canada. This is different from fair use in the US. Fair use in the US could be for any purpose. In Canada, we are more narrowly focused on these purposes. Our copying must fit one of these purposes. And you might think, okay, great, I know what section of the Copyright Act this is in. I'm going to go read it. I'm going to know all about fair dealing and how to exercise this. And unfortunately, it's not quite that simple. We can see what the purposes are. We know that we are allowed to fairly deal in Canada, but the test or how we apply this actually comes to us from case law, especially from the Supreme Court of Canada, not directly from the Copyright Act. And here I've listed one of the leading cases on fair dealing, which is CCH and Law Society of Upper Canada. But you can see how the court looks at this And what they did was develop a test to know when we can use something and whether or not it's a fair dealing. And there are 2 steps and 6 factors to this test. The first step is just, does this fit one of these fair dealing purposes? That's the first thing we need to make sure. That is our grounding, our basis for ever fairly dealing. Next, we have a balancing test, and we sort of have to look at the impact of the use of the work, how detrimental it is to the copyright owner, how beneficial it is, etc. And basically, we have to balance the factors to determine whether or not copying is fair. And looking at those 6 factors, we look at the purpose again, or some like to call it the goal. I like to call it the goal just to differentiate between the purposes enunciated in the Copyright Act. But what is the goal? What is the reason behind the copy that you're making? So for example, if we're thinking about impact of a copy that's being made, something like a non-commercial purpose, often going to probably have a tendency to be a bit fairer than something like a commercial purpose. We have to look at the amount of the work that's being copied and the character of the copying that's being done. So for fair dealing purposes, although perhaps a whole work could be fair in some situations to make a copy of, we need to think about, what is the purpose? Is it criticism, review? How much of that work do I actually need to reuse for that purpose? How do I have to distribute that work to achieve that purpose? Can I, for example, write an article? Maybe it's just for a class, I give it to a few people and I have a fair dealing copy of some work that I'm criticizing. Will that work versus, for example, just putting it online where anyone could see it? That might be potentially a bit less fair because someone might access it for something other than a fair dealing purpose, etc. When we're thinking about the character, what we are copying from a work, we need to think about whether it's something like the integral part. Am I copying the thrilling conclusion of a book and putting that online so that, everyone goes and reads the final chapter because I've made that available? That might have a very negative effect, for example, on things like book sales. Whereas if I'm using just a part of the text because I'm doing it for purposes of review, maybe I'm writing a review of that book, that might be something that would tend towards more fairness. Again, thinking about the balancing. Are there any alternatives to me using the work? So for example, is there a non-copyright protected work I could use instead for the purpose? It's going to have essentially the same effect. In those cases, it would probably be fairer for me to use that work than for me to make the reproduction. What is the nature of the work that I'm reproducing? And copyright law does look at things like making information available. That's something that sometimes it can be fairer to make a copy of something that's maybe not that available so that it can be disseminated to the public. But I often, as an example for this, when we're thinking about the nature of the work, say, if something is confidential, maybe private letters that no one ever published or made publicly available, you'd want to think about, is that something that we'd expect to be broadly distributed or not? It may or may not tend towards fairness, depending on the kind of work that we're reproducing. And finally, also the market for the work. So by me making this copy and making it available in whichever way I have, am I severely impacting the creator? Am I making it so that they're perhaps losing sales in a really marked way that is potentially unfair? So we need to look at all 6 of these factors, balance them, and it's always a contextual analysis. As with any legal analysis, we really need to think about what we're reproducing, how we're reproducing it, and then think about whether or not it's fair. Ultimately, it's something only a court can decide. So we're, in some ways, even me as a lawyer, I'm making educated arguments or educated guesses, but ultimately, whether or not something's fair, that's up to a court. I am mentioning because I know this is sort of something that I think has become more of our public consciousness, especially because this is used in schools and universities. But most educational institutions in Canada, they have adopted this 10% or one chapter from a book or one article from a journal standard as something that's fair to provide to students for educational purposes. I just want to point out that this is just a guideline. This is not something that we can just take as a rule of thumb to use in every and all situations. And that this guideline was very specific to education. As I was saying, it's always a contextual analysis, and the way in which this material is provided to students is very specific to educational situations. So you might read about that, you might see it online, but take it as a guideline, and always think about your own context. How are you making a copy, etc., if you are wanting to rely on fair dealing. We also have the user-generated content exemption. This is fairly new. We have, unless I'm very mistaken, no case law on this ever. It's called the YouTuber mashup exemption. And basically, it is what allows us to make YouTube videos, as we're probably all very familiar with on YouTube. It allows individual users, and that's important, probably not a corporation or an organization, but an individual user, to use parts of other copyright protected works as long as they've been made available to the public. And you can create a new work and share that work. When you do this, it has to be for non-commercial purposes. So I can't use this exemption to make a video that I want to sell, for example. We have to have reasonable grounds to believe the work that was used was not infringing. So I can't go to a questionable website, download something and say, okay, I'm going to use this with the user-generated content exemption. No, it has to be legally acquired version of the work. And also, as I mentioned before, no breaking technological protection measures. That's going to be the case all the way through when we're thinking about any copyright exemptions. We can't have adverse effects on the market for the original work. So I like to think of the example, if there was a movie, I can't say, I'm going to use user-generated content exemption and use 90% of the movie and then put, 10% a new ending or something like that. That would not be okay under this exemption, because I bet a lot of people would maybe watch the version that you made and might not go and actually pay to see the movie themselves. So that could be an adverse effect. And we need to provide citation. With fair dealing too, in some contexts and with other exemptions, even though, as I said, plagiarism, citation, etc., is a different matter than the economic rights under copyright law, we do have some exemptions that say you better provide credit. That is something that's important, and probably too, for example, the moral rights of a creator in any respect. But with this one, we do need to provide citation where possible. Same of author, performer, maker, broadcaster. And I mentioned moral rights again with this exemption because we do want to think, if you're making a modification, you're using parts of other people's work, could it harm the reputation in some way? Might they have a claim to say that? We don't really know how moral rights and this exemption will operate together, but it's something I bring up to people just so you're thinking of it. If you want to do something that criticizes what an artist believes in, maybe with their work using this exemption, maybe they have a moral rights claim. So it's something to think about. Now, I've mentioned some exemptions, but I have also mentioned copyright. Well, it does last after the creator is dead. An heir can inherit copyright. It doesn't last forever. And when copyright ends, works will go into something called the public domain. Our current public domain period, or copyright period for when something goes into the public domain, is 70 years after the year of death of the author. And that's important. It's not necessarily going to be the copyright owner. This is one of those situations where we might have to figure out who the author or creator was. And this is for a general term of copyright and when work will go into the public domain. Now, while I say it's 70 years, we're in sort of a strange transition period at the moment, because we've had very recent changes to the Copyright Act, actually in December of last year, which increased our term of copyright from 50 years up to that 70. But in doing so, the government said, we're not going to make it retroactive. So works did not become copyright protected again. Instead, we're sort of having a lacuna, or a void of 20 years where nothing new is going to go into the public domain. So essentially, until 2043, things are going to remain the same. If an author died in 1971 or earlier, their work will be in the public domain, but nothing new will enter until 2043, when our 70 years will kick in again. And if someone died in 1972 or earlier, their work is in the public domain. So 1971 is going to be an important year for public domain dates for the next 20 years. I want to mention, I'm mentioning the general term of copyright. This is the one that you'll probably hear about the most, but there are different terms for different types of work. So sometimes it's important to check on that too if you are hoping to use something in the public domain. Sound recordings, video recordings, they do have different terms, can often be 70 years after something is published. Photographs have many different aspects to them. So photographs too, that's another thing that's can be important to check on public domain terms for them. So once something is in the public domain, the work is no longer subject to copyright. It can be copied, modified, adapted, reused, etc. We don't need to get permission from anyone. There are no longer moral rights. I say still a good idea to provide citation or attribution. That's probably me coming from an academic background, but we do want to make sure we're giving credit where it's due, not plagiarizing. Maybe it's not a legal issue, but certainly an ethical issue, even with a public domain work. I do caution about the public domain because it can be sometimes easy to get a little confused about this. Let's say we have a book of Shakespeare's plays. Obviously, Shakespeare's been dead for a very long time. But let's say it's a new edition and the compiler or the editor has put together the plays. They've added some essays that were recently written. They've written an introduction. Maybe there's some annotations. All that other material is new. It will not, just by virtue of being about Shakespeare or in a work with other of Shakespeare's public domain works, automatically become public domain either. So we need to remember sometimes we have mix and match. We might have public domain and copyright protected works together. And the other thing, and I hope this is obvious or apparent by now, but we need to make sure that we're not thinking about the term public domain in a more colloquial way as publicly available. Because sometimes I hear that too. People will say, oh, public domain, great. It's public domain because it's in the library. It's public domain because it's online. And we're using that sort of as a synonym for publicly available. For copyright purposes, no. When we say public domain, we mean that it has been long enough that copyright no longer exists in the work because the author has passed or a certain amount of time has gone by since something was published. Copyright online, I talk about this a little just because it's, again, to mention something on the internet. Just because it's there doesn't mean it's free to copy and share. There are a lot of free to use or free to reuse on certain terms, resources. I'm going to talk about those a little bit. I do mention this though, just because I think especially our social media norms are not always very copyright conscious. So I like to mention we need to think about copyright online carefully. For copyright online, you may be familiar with the notice and notice regime in Canada. This relates to allegations of copyright infringement, and that's uploading or downloading content without paying or permission. Basically, what happens is a copyright holder, the representative, might have reason to believe that someone's downloaded or uploaded their copyright protected work without permission. And what they'll do is they'll identify an IP, so an internet protocol address. They'll know that this IP, so usually it's going to give us a location, a service provider, and that's who we think did this downloading or uploading. What the IP address doesn't do is tell us who the user is. So this regime allows, and the Canadian government said, you know, what we want to be able to do is if this is going on, that copyright owner or the representative can contact the internet service provider. They can say, this is the IP address that we think has done something. Here's a notice. You need to let them know that we think they're infringing our copyright. They need to stop. The internet service provider passes along that notice. There's certainly been lots about this in the news, not so much lately, but in prior years. Generally, when the notice is passed along, we hope people will correct any behavior that might have been happening. In the event this perhaps was happening a lot, a copyright owner can try to find out who the person is behind that IP address. They would have to go to court to determine who that is. Happens sometimes, but again, I haven't heard about this as much as of late. At one time, these notices could contain settlement demands. So they could say, you know, we think you owe us $2,000 for this download, pay us that, and we won't pursue you in court. The Canadian government said that was not the purpose of this regime. This regime was not meant to pass along a notice so that someone could try and get paid like this without having to go to court and prove it, and et cetera, et cetera. New regulations said to an internet service provider that if someone sends a notice with a demand like that, you don't have to pass it on. So we don't see that as much these days. I mentioned if you're wanting to copy something from websites, I usually suggest it's a good idea to check terms of use or copyright notice on the sites. You'll usually find this in the footer of the website. And these terms of use are really meant to be like an agreement between the user of the website and the creator or owner of the website. Sometimes when we go in there, we will find that they might permit or restrict copying. In some cases, especially for educational purposes, they might actually permit it. So you want to look through and see, are there any conditions, anything that maybe I need to know if I'm thinking of using something from the site? And remember, you can always ask permission. So if you do see something on the site, you'd like to reuse it, maybe you can contact them and see if that's possible. I mentioned on many websites, stock photos are used. Usually those are licensed. So the copyright owner will not be the site itself. It'll be someone else who they've gotten permission from. And the other thing I like to mention is linking. Sometimes when we want to use something from a website, we can use a link instead. Links are generally copyright friendly because we're redirecting someone to a site. We're not actually making a copy of it. I want to make sure anything we're linking to is legally posted. But generally that's a good method we can use. Although we do need to think, there's some new case law coming out, are we making a link available to the same group of people who would have been able to access it anyway? There might be problems if we make links available to people who otherwise would not have been able to get access to a site, for example. So if you do want to find free to reuse content, where can we find that? There are lots of websites, so I'll talk a bit about some of those. We also have openly licensed content, so that's under an open license, something like Creative Commons, which I'll talk about more, or open access materials. So first, Creative Commons. Creative Commons is an organization that's dedicated to sharing free resources. And what they've done is created a series of legal licenses that help to bridge the gap between full copyright protection and the public domain. And basically, these licenses tell you you may do certain things with the work. The creator decides to apply the license. It tells users how they can use the work, but usually there are certain restrictions or certain conditions we need to meet. Minimally, we're required to provide attribution. We always want to give credit, especially with Creative Commons licenses. Licenses is like an agreement. So to benefit from the terms of the license, to be able to reuse the material, you need to follow those terms as well. So it's a give and take between the creator and the copyright user. I do note here too, we always want to have some caution when we're using Creative Commons licenses or any materials online. Do a bit of due diligence. Creative Commons licenses can only be applied by the creator. They are something that's supposed to be perpetual, so the creator cannot remove them. But if you find something online that you kind of go, I'm surprised by that, like this New York Times bestseller that's still on the bestsellers list, I could buy it in a shop, here it is free with a Creative Commons license, I would question that. I would do a little more due diligence to make sure I am using a valid license and not something that might have been done without the creator's permission. So Creative Commons licenses have a series of components. The one I mentioned that's on almost all of them is the attribution. So when we're reusing something under a license, we need to make sure that we're providing credit to the creator. If something is modifiable under the other terms of the license, we need to make sure we're saying that we made changes. And Creative Commons suggests when we are providing an attribution, we want title, author, source, and the license. And that's really important. We want to put the license, a link back to the text of the license so other people can reuse materials under the same terms you did. This money sign crossed out, that's non-commercial use only. We'll see that a lot. And what does that mean? Generally, non-commercial use is going to mean I can't use it in a way that I might profit from. So the creator is saying you're free to use it, but you shouldn't be trying to profit from my work. Share alike, when we see this arrow spinning on itself, if I reuse something under this, I modify it, I make something new. So I take an image, I make a collage, I put it in there, I have to use the same license. So it's a pay it forward kind of license. I'm using something share alike, I must share whatever I make alike too. And then we have the no derivatives, which I think of as the most tricky of these components, but it's basically something you can view as a share only or a read only. I can't make changes. If I make changes, I can't share that modified version. So here's just an example I found on Flickr. If I want to reuse this image, I can see down here where I've got the arrow that some rights are reserved. I see those components of the Creative Commons license. If I click on that, it's going to take me to the text of the license. And I can read through that and see how I am permitted to reuse this. So here's the example. I'm free to share, adapt, and here are the terms. So as long as I follow these terms, I get the benefit of doing all the sharing and adapting, et cetera, that the license permits. So here are just some examples of places you can look for these kinds of free to use images. Library and Archives Canada, a lot of art institutes, et cetera, are good choices to look for this. We can look at sites like Pixabay or Unsplash I've mentioned. These are sites that have basically stock photos that say you can use them as if they're in the public domain. With any website, I will always suggest when you go to it, read all the terms, find out what their license says, find out what it says about reusing things. One thing that's a big caution is that some of these sites will have a mixture. They'll have both images that are pay to reuse and free to reuse. So again, you want to make sure you're doing your due diligence so you don't run into a problem down the road. We can also find ways to search for these kinds of things using something like Google or Bing. So just going to give a little example of that. As you can see here, I've done my copyright search. If I go to the Images tab, I can go to Tools. By clicking on Tools, I'm going to drop down these additional options. So size, color, and usage rights. And that's what I want. If I click on that, I can search for Creative Commons licenses. This is a good way to filter so I can find some of these free to reuse images. As I just said, though, you still want to go back to the website, click on the image, click all the way back to the site, read the terms of the license, make sure everything looks okay, because Google's not always right. In my experience, sometimes you go back and you're like, whoa, why did they think this had a Creative Commons license? And sometimes I find, especially the first row of results, they'll have things that are for commercial reuse. I'm not sure why, but again, it's just, we need to do our due diligence and be wary when we are reusing these kinds of materials. So books that are free to reuse, LibriVox for audiobooks, Project Gutenberg or Project Gutenberg Canada, or the US Library of Congress. Do you want to be a little cautious with public domain materials from other countries because our public domain terms can be different, but these are still sources where you can find things. The Internet Archive has a lot of public domain things. They have some things that also use a fairly novel application of fair use or fair dealing called controlled digital lending. So sometimes you'll find those things too. And it's again, you know, whether you feel comfortable using things under those terms. Music and videos, there are a lot of places you can find things that are free to reuse too. Always read the terms, as I said. I mentioned YouTube here because you can do a Creative Commons license search. Certainly not everything on YouTube is Creative Commons, but you can find things that are free to reuse. Then open access. So many materials are now being made openly accessible. We find this a lot with educational materials or academic journals. Usually these will have Creative Commons licenses too, but sometimes they won't allow the modifications, et cetera, that we find under Creative Commons licenses. Sometimes it really is, you're free to access, free to use, maybe free to share, not always free to make changes. Canadian government too, we're finding is funding more and more open access. Public funds should make works that are publicly available. So we find that with Tri-Council grant funding, also some Creative Commons license news sources are getting more government funding as well. Now I mentioned government works. Sometimes people say I'm using government works. They're public, right? I paid for them with my tax dollars. Surely I can reuse them. They are actually subject to something called Crown copyright. This means that after publication of a work, there's 50 years of copyright protection of Crown works. So federal works, provincial works, etc. Pardon me. There's also the prerogative of the Crown. Potentially, they could extend a term of copyright. If something's unpublished, it has perpetual copyright when it's a government work. Now, having said that, there is a real movement towards using open government licenses, and these basically are the government's version of Creative Commons licenses. They allow you to do a lot of the same things. You're going to find them, you know, both in federal departments and in Manitoba, but the use of them is not uniform, and I can't stress that enough. Any federal government department, you're going to have to check on their website, look at their terms, see whether or not they're using this license. There's also a federal directive under which most federal works can be copied, unless there's a restriction on the work itself. And usually under the terms that we need to attribute, we can't modify, can't make it seem like this is the official version or there's any endorsement by the government. But certainly things like statutes, cases, etc., those are things that we can reproduce because of this kind of directive. So open government license, Canada, that's for federal works. Manitoba is using an open Manitoba information and data use license. I think this is uniformly applied throughout Manitoba's government sites, but again, you'd want to check on that. It is, as I say, basically their version of Creative Commons license. It allows very broad reuse, but we need to do things like make sure we're attributing, link to the license, etc. If there isn't one of these licenses, so maybe another province that doesn't have them, you can still think about whether copyright exemptions can be applied to Crown works, even though they are Crown works. But if you want to make a use that's beyond either a license or an exemption would allow, we need to think about getting permission. I mentioned under US federal law, government works are in the public domain, but US law does not apply in Canada. This is something I'll talk about in a second, but copyright is territorial. So it's going to be different in different countries, even if it's similar. And I mentioned that because we'll find NASA works and things like that from different US government departments. They'll say public domain. So in the US, they are. In Canada, potentially they have copyright protection. In my experience, usually they're treated often as if they are public domain in Canada. Actually asking the federal government in the US for permission in past, they've sort of gone as public domain. Why are you asking? But just important to note, because there is certainly a possibility that they could be treated as copyright protected within Canada. When we're thinking about copyright law, which do we use? Generally, you want to apply the law of the place that you're doing the copying. So within Canada, we're applying Canadian law. And that's again because copyright is territorial. We have international conventions that do give us different ways that copyright is interpreted in different regions. It's kind of uniform in that way, but everyone's applied the law slightly different. So there are going to be different rules. The internet can make the assessment of which law applies a little difficult because if we're posting works available worldwide to servers in one country, copy was made in another country, someone's accessing it somewhere else, this can start to become a bit tricky. And I have heard of situations where, someone has said, hey, that's still copyright protected in my jurisdiction. You've made it available to everybody there, even though it's public domain in Canada. Is this an issue? So it can be tricky online. I do also say this just for caution when you're reading internet sources about copyright. So if something you learned today, you're like, oh, I want to learn more about that. We want to make sure that you're looking at something about Canadian law or wherever you're doing the copying. And I say this especially with something like fair dealing, because very often, people come to me and say, well, I was reading this about fair use. And I have to go, that's the American version. Similar, not the same. We want to make sure that we're applying the law of the country we're making the copy in. Now, the other thing about copyright that I like to tell everyone is that copyright changes. Copyright is actually quite dynamic. So you might have learned something about copyright last year. It might be different this year. So for example, the copyright duration, that 70-year term, that is new. It was recently extended. And the Copyright Act itself has a baked-in provision that says every 5 years, we're going to have a review by the federal government. So we had one that actually probably should have started last year. We're thinking it's going to start sometime this year. But we know another review is coming, and the government has said, we need to look at certain aspects, for example, of the educational copying market. So we often are anticipating copyright changes. So it's important to remember that. If you learned something a while ago, you might want to brush up and just see, okay, what is the status of copyright now? Because it's quite dynamic, especially with new things like AI. I think AI and authorship and of AI generated materials, those are going to be things that we'll probably be looking at in that Copyright Act in the very near future. So that brings me to my end of my rundown of copyright. So copyright for creators, for users, different kinds of materials you can use, etc. And I'm very happy to take any questions now if there are any. And you're welcome to write them in the chat, or if someone wants to put their hands up or unmute, I'm happy to do that too.
Yeah, I think they can just use the chat or use
Okay,
the Q&A.
sure.
So maybe we'll give them a minute or two. It was a lot of information, excellent information, but a lot to
Mm.
take in. Okay. Um, well, I'd like to thank you, Althea, for an excellent presentation. Um, always a great presentation. I want to thank everybody also for attending. I hope you enjoyed the presentation. And I guess if you have any questions, you can always forward them to me and I can then maybe forward them to Althea if that's okay with you.
Oh, absolutely. I'd be happy to do that. Thank you so much for having me today.
Oh, thank you again for presenting. To all of you who have joined us, please fill out the survey. It's very short, but we do use your suggestions to improve our presentations and to plan new ones. Our next set of webinars will be the week of March 20th. So March 20th will be protection orders. March 22nd, we'll be creating a culture of consent in the workplace. March 24th will be changes in family law. All of them start at noon. They're free, but you have to register. So that information will be on our website shortly. So thank you all again for joining us. Thank you again, Althea, and everybody have a great evening. Okay, good night all.